All right, for our next panel, it's titled Commercial Partnerships, the Private Sector's Critical Role in Space Power, Policy, and Law. To moderate this panel, we welcome another great friend to the Law, Technology, and Warfare Research Cell, Dr. Andrea Harrington. Dr. Harrington serves as the Dean of Space Education at Air University. Prior to her current role, she served as the chair of the Department of Space Power and director of the Schriever Scholars concentration at Air Command and Staff College, where she's an associate professor of military and security studies. Over to you, Dr. Harrington.
Thank you very much for the kind introduction. And just for a note, we're dispensing with lengthy bios for today, as you all have access to them in your bio book, so we can spend more time engaged with our really fantastic panelists that we have assembled for today. I'm very pleased and honored to be here moderating the Commercial Partnerships panel, which I think will fit very well in with the discussion from the Space Traffic Management and Space Situational Awareness panel that you all heard just before lunch. To give my initial disclaimer, my comments here today are my own views and opinions and do not represent the views of the U.S. Space Force, U.S. Air Force, or any other part of the U.S. government. And the same goes for our panelists that are here today as well. So from a procedural perspective, each of our panelists will speak for about 10 minutes, and we will hold all questions until all four panelists have had the opportunity to give their comments. And then you'll be welcome to ask questions to any member or multiple members of the panel that you would like after their comments. And I may choose to take moderator's privilege in inserting some of my questions as well. Overall, the focus of this panel today is going to be the complexity of the legal and regulatory relationships within American governance of our domestic space activities. So different rules apply depending on whether an activity is a government activity or a private/commercial activity, but these lines can often be blurred through commercial partnerships and contracting. To that end, first, Sabrina will discuss the delineation of applicable laws and regulations between launches by the government versus launches for the government. She's speaking from the perspective that she has gained in the FAA. And then Karen from Relativity Space will bring in the commercial perspective to talk about those distinctions, particularly with a focus on range operations. Then we'll have Maryanne from Lockheed Martin to discuss the pros, cons, and pitfalls of government contracting. And finally, Michelle from the University of Mississippi will bring in the academic perspective, tying in the role of the military in protecting commercial space assets, particularly as we heard yesterday from the panel about Russia and Ukraine, in light of some of the activities that are being carried on by commercial entities relative to armed conflicts or potential armed conflicts. So as I said, we have a fantastic and really impressive panel that I'm excited to hear from today. And with that, over to you, Sabrina.
Thank you. Thank you so much for having me. I also just want to give an extra special thanks to everyone that I spoke to today on my unplanned 45-minute journey to try and find this place. You all have been so helpful. I think I spoke with at least 20 people. So thank you so much for being so welcoming. I'm going to talk a little bit about the structure and sort of the legal authorization that the FAA has and how it is that we determine whether or not we license a mission that has some government involvement. So this panel is focused on public-private partnerships, and the FAA has been involved in looking at these partnerships for quite some time. What we look to first, of course, is our statute. So the authorizing statute that I work with over at the FAA is Title 51 of the U.S. Code, Chapter 509. And that statute gives us the authority to license commercial space transportation. So basically launches and reentries that are conducted by the commercial sector. Now, there are some exceptions as to what we are allowed to license, and those exceptions are in Section 50919G. And in particular, in that subsection, it states that the FAA does not license launches for the government by the government. So let's talk a little bit about how we determine whether or not a public-private partnership would be licensed by the FAA. How does the FAA look at this two-pronged test? Well, We can dispense pretty quickly with the for the government prong. When we're deciding whether or not a launch is for the government, that means that there is a governmental purpose. So what we think of is, let's say that the Air Force or NASA is interested in launching a payload, a satellite. They're interested in sending some astronauts up to the ISS. That's a government purpose and would satisfy the for the government prong. When it gets a little bit more complicated is when we're trying to decide whether the launch is also by the government. So I think a more straightforward example would be the shuttle, where it was operated by the government and it was for a governmental purpose to send astronauts up into space. What we've seen, I will say recently, but it's really been for quite some time. What we've seen in some of these public-private partnerships as the shuttle has been retired many, many years ago is that the by the government prong has been a little bit blurred as NASA and other government entities have contracted with commercial operators to help them to complete their missions up in space. So what the FAA does in order to determine whether or not a launch is by the government is it looks at who is essentially controlling the launch. And in fact, we have asked, well, we didn't, NASA asked DOJ to weigh in on this issue back in the 1990s when NASA was launching a satellite and there was a bit of a conflict of opinion about whether or not that particular launch should have been authorized by the FAA. The FAA's position was, and I'll give you a little bit more background. So NASA was launching a satellite. They were contracting with General Dynamics to conduct that launch. DOT believed at the time that they should be licensing the launch because General Dynamics, who is a commercial operator, was involved in the conduct in the operation of the launch. NASA, on the other hand, felt that this was a for the government by the government launch, that this launch included a government satellite, and that even though they were contracting with General Dynamics, there were significant contract terms that allowed them to essentially control a large portion of the launch. But really NASA's position was, we're sending up one of our satellites. This is for the government by the government. DOT should not be licensing. DOJ, Office of Legal Counsel, stepped in and said, you're both wrong. We agree with neither of you. And in fact, it is something somewhere in the middle, as lawyers are wont to say. And what DOJ said was, we need to look on a case-by-case basis at really who is substantially controlling the conduct of the launch. There weren't a lot of details provided. They did talk specifically about the details for that particular launch. DOJ's opinion also focused on the fact that the Commercial Space Launch Act's purpose is to vest the Department of Transportation in authorizing commercial launches. They also talked about how some of the financial responsibility requirements in the statute would be rendered meaningless if the Department of Transportation licensed such a launch. I tend to disagree at this point in time, but they had their own reasoning about that. And they also finally said that in this particular instance, there were enough substantial contractual terms in the agreements between NASA and General Dynamics such that they could make a determination that it was actually NASA that was substantially and substantively controlling the launch. So when we get into some of these commercial public-private partnerships, and when we get into issues where the government entity might have significant control over, let's say, the design of the vehicle, go, no-go determinations, they might even sit on Counsel. This is when the FAA might have to look very closely at whether or not they actually have the authority under Title 51 to license the launch. So now we have an understanding of when the FAA licenses and when they don't license a launch where there's a commercial, where there's a public-private partnership. I also just want to talk very briefly about a specific example of some issues that come up when the FAA does license a launch where there is a government agency involved. So let's think about, fast forward, the Commercial Crew Program, where NASA has contracted with commercial entities to send astronauts up to the ISS as the shuttle has been retired, and we wanted to bring that back into the domestic field. The Commercial Crew Program brought up a number of very interesting questions because while the FAA did determine that they would be licensing these commercial crew launches, there were uniquenesses about this particular public-private partnership that didn't fit nicely into the FAA regulations. And one example in particular is the fact that these launches sent up government astronauts, so NASA-trained astronauts into space. Now, The FAA regulations and statute at the time contemplated only two types of people that could be on board a launch vehicle: crew, which were employees of the operator, in this case, the commercial operator, and spaceflight participants, which is everyone else. And when the statute and regulations were originally promulgated, the idea was that spaceflight participants would probably be tourists. They would probably be people that were going up that didn't have any specialized training. Government astronauts don't really fit nicely into either of those categories. They do have specialized training. And in fact, we may even want them to have the ability to pilot the vehicle, which the regulations specifically said spaceflight participants could not do, only crew could do. So the FAA and NASA worked very closely together to try and figure out what tools do we have in our tool belt to work around some of these issues. And there are many, fortunately. The FAA has authority by statute to waive its regulations as long as it makes a finding that the waiver of the regulations will not jeopardize public health and safety, safety of property, or the national security and national security and foreign policy of the United States. In addition, the FAA issues legal interpretations, and we actually did this for the commercial crew program, where we look closely at our regulations and we say, yea, verily, within our sort of authority, we are going to interpret and implement our regulations in this way. And so we issued a number of legal interpretations where we stated that government astronauts were carved out of certain things and that it wouldn't have made sense based on our statutory authority not to do this. So informed consent as an example, cross waivers are an example. We also talked about piloting the vehicle and why it is that government astronauts shouldn't be considered spaceflight participants for those purposes. But ultimately, we ended up with a legislative fix with the Commercial Space Launch Competitiveness Act in 2015, where Congress decided to create a separate category of government astronaut, which made it so much easier for us. And we are actually still working on promulgating the regulations that will put that into the CFR. But that's just a quick example of some of the challenges that the FAA has faced when we look at some of these public-private partnerships. Because when we're working with an operation that is government and commercial, there are instances and examples of things that happen that the regulations weren't necessarily written to accommodate, or that the statute wasn't written to accommodate. And so we have those flexibilities to help us. So I will go ahead and stop there.
Fantastic. Thank you. Over to you, Kim.
Thank you so much. And such an honor to be here. And it's been a pleasure to meet so many of you in person and to talk to you about the exciting work that we're all doing. I've had the honor to both teach and work in this field. And so today I'll kind of come with personal comments, but based on experience of a decade at SpaceX and now 2.5 years at Relativity. And that included working on the commercial crew program and being very much involved in the 2015 law change to enact that government astronaut definition, as well as some changes to the liability provisions governing and the waivers governing spaceflight participants. I spend most of my time now, though, thinking about launch. We're on the verge of launching the first nearly fully 3D printed, 85% 3D printed vehicle. Stay tuned on March 8th. And with that, navigating the FAA regulations that have recently been updated for launch Part 450, and the challenges that have come with that and getting the license that we just recently received. It is important to note that the FAA is not the only regulator of launch. We are also regulated by the FCC because we have to use spectrum to communicate with our vehicles. So I have to go to the FCC to get a license, which means that I actually have to go to the NTIA because we're operating from a government range. So we're using government spectrum, government designated primary spectrum. And so negotiating through that is always interesting. And then I also get to talk to NOAA because we have cameras on board, which could capture images of other things. And thankfully, the recent NOAA regulation update, so actually it's been about 3 years, includes a carve out now that didn't previously exist. So it previously was getting these licenses for viewing separation events and events relative to the vehicle. So you actually go and tell NOAA what you're going to do. And thankfully, in this case, they tell you you're good, you don't actually need a license. So those are the 3 that we talked to today. In the future, I look forward to talking to the Department of Commerce about in-space activities and look forward to seeing how those regulations shape up as we think about things like putting 3D printers on Mars. I also think an interesting part of the conversation about commercial partnerships with government is so we've got we provide services to the government and what those look like in the contracts, and how those contracts define whether we're FAA licensed, for example, or not, because that's a key aspect of the contract. And so this, the CRESS conversation is often solved by virtue of the contract, which dictates that you would be FAA licensed now. The crew contract and the cargo contracts being examples of that. So you've got the customer, the government as a customer, the government as a regulator, and then you also have the government as a service provider. So, when we're operating on federal facilities, like for example, the range where we launch from at Launch Complex 16, we're on the Cape Canaveral Space Force side of Cape Kennedy. We are subject to the flight safety requirements and the ground safety requirements of the Department of Defense. So for ground safety, for example, we're looking to DDESB for explosive sighting requirements and approval. We're of course working with the Space Launch Deltas for doing our flight safety analysis, and we pay for those services, of course. So that's something where the government is providing a service to us for which we reimburse the government. We are responsible for the license to use the facility. So we negotiate those. We have, of course, CREDAs for the services that were provided. And then we also operate Relativity and other commercial entities on NASA facilities. So where we're using NASA facilities and NASA services. And again, we have agreements for those facilities where we pay for services and we have to operate our facilities. In some cases, people pay the government to support those with their infrastructure, and others you're licensing or leasing facilities. And then you're building your own facilities and you're responsible for maintaining those in accordance with your agreement, your license or your lease with the government. So there's a lot of ways that we interact with the government, and it's always interesting to see how sometimes these things come into conflict with each other. Where we have a government customer that's interested in a certain outcome. For example, NASA with Crew wants to be able to bring astronauts to a launch that's an FAA licensed launch that's not a crew launch, so they could see how things operate and be close to the vehicle. But the FAA regime does not allow the government astronaut, which is not involved with the launch that's actually happening on that day, to be on site, because then they're third parties. So you've got these fun conflicts of things that happen between one government entity, another government entity, or even within the same government entity. So it certainly is an interesting place to operate, where we're partners. Sometimes we're negotiating on the different sides of the line. Always, though, I think at the end of the day, thankfully aligned in the mission to achieve national success and national capabilities with regard to space launch and space exploration. So I think those are a couple of things that I really wanted to point out with regard to some of these activities, and I think a good follow on to Sabrina's comments. So I'll pass it on from there.
Great. Well, thank you. And my name is Maryanne Lavan, General Counsel of Lockheed Martin. Thank you for having me here in this gorgeous facility. And also I've learned on the panels, I'm learning on this panel. So where I would describe my interaction with space is sort of like I'm a mile wide and inch deep. I know enough to be dangerous. So in any event, I thought I'd give a little preview about space and then talk a little bit about some of our work, and then just talk a little bit about the commercial. So in terms of space, it's one of the 4 business areas at Lockheed Martin. It's about 18% of our business. And we, when I was trying to think of a perspective that I could bring to this panel, we're in a unique position. So Lockheed Martin is this big company. And in space, though, we do military work in space, and we also do commercial. So we have those two. And then we're watching the commercial market develop. So when we think of like a big bureaucracy like Lockheed Martin, how do we adapt? How do we be agile? How do we change? And it's fascinating to watch, and we're all learning from it. And as I learned from all these panels today, space is crowded, space is busy, and we're still learning the governance aspect of it. So I'm thinking it's a lot of risk, but a lot of opportunity. So when we think of space, so they're about 18% of Lockheed Martin. The other 3 business areas are aeronautics, which think airplanes, rotary mission systems, think helicopters, missiles and fire control, think missiles, and then space. And within that, they do various ground systems, lunar, and I'm going to put my glasses on so I can see the other surveillance and navigation and global communications. But within that, the commercial and the military and space, we don't break it down by segments publicly, but say about half of the work is in space. And so our employees are just awesome and excited to come to work every day. And I'm going to show you a few of the things that they've worked on recently as I get the clicker out of my pocket. Okay. So the first thing is the Artemis rocket, and that happened this year. And it was launched in November of 2022. And it was a 25-day mission, and it was Orion crew module returned to Earth on December 11th, 2022, and it completed a 1.4 million mile mission around the moon and back. And we build the Orion crew, and then we work with commercial subcontractors, and we also work the European space agencies on that. And then on that was really, there's another picture of the Orion crew module there. But on that, we had something called Callisto, which I didn't, someone had explained it to me. Basically, it's Alexis in deep space. So that's a lot of fun. And we learned a lot from that. So that was really, really great. And then the final item I wanted to highlight is in collaboration with NASA and the University of Arizona, we support NASA's OSSPACECOM mission to study a near-Earth asteroid. It was launched in September of 2016, and it rendezvoused with an asteroid, conducted a 2-year detailed study. I'm just going to bring back a sample, and they'll be back in September 24th, 2023. So that'll be really exciting and interesting. So those are all some of the things that we work on to make it an exciting place for all of us to work. I thought I'd switch a little bit in terms of, what we see in terms of the commercial area, and if the government wants to continue with the commercial partnerships, encourage commercial partnerships, there's a few things that we should keep in mind. Now, I kind of hesitate to that because it's basically creating competitors for Lockheed Martin, but that's okay. And I think it's important that we have the commercial entity. And I think a few things, and again, I'm not speaking on behalf of the commercial entities, but these are also issues that we see outside of space when we're trying to negotiate or collaborate with commercial entities. So for instance, one thing to think about is the stream of the government revenue. Is there enough investment? Is there enough transparency that a smaller company will want to either invest or go forward in that if they can't understand the funding, and will there be funding for next year, and will they be able to continue the work that they would like to do? The other things that I think about in commercial world, the profit margin is a little higher than it is in government contracts. So commercial, why would I want to go into potential government contracts? Because the profit margin is a little different. I'm not saying that's positive or negative, but it's something that a commercial entity would think about. Other things that they would think about most likely is cost of pricing data. So if they get enough government contracts work, do they have to set up a whole separate accounting provision and procedures? And I think a lot of companies would say, no, that's just too much, And then finally, the third rail I'll touch on is IP. So government has certain reviews of IP, but commercial world looks at it slightly differently. And so I think the way to move forward, the most discussion on this in terms of commercialization in space is probably have a discussion around that, where you could maybe have a symposium with commercial companies and the government and talk about that and try to come to some sort of resolution. So I'll pass it on.
Thank you. Hi, everybody. My name is Michelle Hanlon. I'm from the University of Mississippi. I am also thrilled to be here and glad to know I wasn't the only one who had difficulty finding this place, which you can see from the road, but you just can't get to.
Satellite.
Exactly. Right. Yeah. So, Jeremy, thank you for the invitation and hats off to you. This is an incredible event. So I am going to put my professor hat on. We're hearing about blurry lines. We're hearing about a lot of great things going on. And I'm just going to warn you now, I'm going to have a lot more questions than I'm going to have answers for you, as any good professor would, right? So in organizing my thoughts and reviewing the Millamos manual and the Romero manuals that you will hear about later, I actually think it's time for an Oxford manual, Oxford, Mississippi manual on defense and commercial space together. So I just plant that in your heads now, because there are a lot of questions that need to be answered. So let me frame out what we know with respect to Space Force. This is the phrases that I've gotten out of it. The essence of military space power is preserving freedom of action in space. We seek space security, defined as the establishment and promotion of stable conditions for the safe and secure access to space activities by the civil, commercial, and intelligence communities, as well as our international partners. And certainly when we talk about protection, we think of the effectiveness and survivability of mission-related military and non-military personnel, equipment, facilities, information, and infrastructure. But we also seek to defend space-based sources of economic power. So that is a really broad remit, right? So that is all of our commercial space, all of what you see here. So what does that actually mean? So I'm a space lawyer, not a LOAC lawyer. So I'm going to talk about it in terms of the Outer Space Treaty. So we have Article 4, which says we are not going to, space is not exclusively for peaceful purposes. Other celestial bodies and the moon are. So in space, we know we cannot put nukes or weapons of mass destruction, but conventional weapons are not prohibited. Article 6 says that the state has international responsibility for national activities of both governmental and non-governmental entities. So this is a unique attribution relationship, right? We don't need to see effective control in order to attribute an action by a national to the state. Article 7 is our launching state liability, and we have the potential under the concept of launching state of 4 different states having responsibility for something bad happening in space. And Article 8 talks about the ownership of the space object. If you register the object, if you send an object to space, you own it forever and ever and ever, and you are responsible for it. All of this is overlaid by the Kessler syndrome. So virtually any aggressive action in space has the potential to create a devastating debris reaction. Under the circumstances, when we think about that, about how we're going to protect our economic power, our infrastructure in space, how aggressive can we be ethically and morally if anything we do is going to contribute to that debris field? So like I said, so many questions. So first, is there a difference between a long-term collaboration or partnership or a contract? So think about, for example, this Civil Space Reserve Fleet. Should we have a Civil Space Reserve Fleet for RPO, the way we have a Civil Air Reserve Fleet to bring troops across the ocean? What would that mean? What would our responsibilities be to that civilian commercial entity? Is it going to be different if we partner from the start, or if we partner once a satellite's on orbit? And what is the difference? We think about, and I wasn't here yesterday, and I'm apologies if I am repeating a lot of the thoughts from yesterday, but what if we have actually launched Starlink to help Ukraine versus allowing the launch of Starlink, which happened to help Ukraine? What does that mean in terms of our responsibility to Starlink? Article 4 says there has a gap. You can put conventional weapons in space. So we saw this morning, should satellites be permitted to arm themselves? We may be a long way from there, but it's still something we need to think about. Should our licensing regime, should the FAA permit a satellite that is able to protect itself with conventional weaponry? Should the FAA require that satellites have enough propulsion to avoid conflict instead of defending themselves? Instead of reacting with aggression, move away. Article 6, we talked about these international obligations, and the U.S. is responsible for Starlink, period. And we saw that with the Russian response to Starlinks being used by the Ukraine, and we saw it with the Chinese response back last year when it complained that Starlink was getting too close to the Chinese space station. They didn't send a note to Elon Musk to say, get out of the way. They sent a note to the US government through the United Nations and said, and very, very helpfully reminded the United States about Article 6, because, we probably forgot about it. And then we talk about Article 7, when we talk about those international obligations, that's liability. And when we think about liability, it's not so much the government has to pay. We have to think about the fact that the taxpayer has to pay. So when we license and when we think about partnering and when we talk about what activities we're going to do in space, we have to bear in mind that our taxpayers are the ones who are going to bear the brunt of our errors, bear the brunt of our aggressions, and also bear the brunt if we don't protect ourselves. Again, so many questions. And then Article 8, if you've sent an object to space, you own that object forever and ever. So is an attack on a commercial space satellite a violation of sovereignty. Certainly, if you hit a ground station here on Earth, somebody else's territory, that violates sovereignty, but we don't have a concept of territory in space. Is Article 8, that concept of ownership, is that enough to convey sovereignty? And that, of course, is important to think about when you are able to claim self-defense. And then moving out of orbit, whole new set of questions. What about the moon? The moon is supposed to be used exclusively for peaceful purposes, but we are very soon sending, when iSpace is actually going to get there hopefully in April safely, but we're sending commercial entities and civilian government entities to the moon, and we're sending them all to the same areas of the moon. The South Pole is where the resources that we need the most, we think that's where they are. So what if China does get there first and builds a perimeter on whatever basis? We've seen what they've done in the South China Seas. What are we going to do then? What if we get there first and China moves in right next to us and we have to worry about things like the plume effect and the fact that they even getting too close can ruin our operational materials. So again, and that brings it all right back to the unique environs of space. In LEO, every event is a debris generating event, even if you're using a non-kinetic system, right? Even if you disable a satellite, the fact that it can't move again makes it a debris generating effect. On the moon, we have the plume effect. So the question is really, how are our hands tied by the concepts of sustainability in space? What are we going to think about? How are we going to work through what is responsible in space? Is it more responsible to protect, or more responsible to cause a debris event? All this is to say, we do need to protect our economic infrastructure, but we need to think through all the repercussions and consequences and balance cost and risk with the case of both Space Force at the licensing level. Thank you.
Thank you very much for all of your comments. So at this point, if there are any comments in the audience or online, I'm happy to open it up for questions. If your question is for all the panelists or any of the panelists, please say so. Or if you want to hear from a specific panelist, please mention that so we make sure that person gets an opportunity to comment.
So, ma'am, we do have a couple of questions that have come in from online. A couple questions related to kind of the resources that private companies use to construct their satellites, their space systems, the propellant that is used. So I'm going to try and group a couple of these questions together, but just generally speaking, the questions kind of revolve around how do you as commercial companies ensure that the systems that you are creating either aren't using harmful materials or harmful resources that could be damaging either to the terrestrial or the outer space environment. And I guess to the extent maybe that there are materials that could be harmful, do you anticipate any sort of ability to clean those up?
I'll jump in first here. So first, I think one of the things that I always like to emphasize when asked about the activities that we engage in is that one of the most important things that we contribute to in terms of the nation, the world, sustainability is space access. So it is only from space that we can really truly understand in many ways what's happening with our climate and with what's happening with snow melt and with water access and with weather, all of these greenhouse gases, right? There are companies that are building capabilities to track, whether there are leaks on pipelines, and only from space we'll be able to capitalize on those capabilities. So I think it's really important to always make sure that we're having a conversation about sustainability when it's like environmental sustainability, and we're looking at a holistic approach and holistic conversation about it. So yes, we burn fossil fuels to get to space, but for getting to space, we won't be able to understand what's happening and take significant actions to mitigate climate change on our planet. So I feel very strongly about the importance of space access and the importance of the role that it plays in environmental sustainability and agricultural sustainability and in supporting human existence on this planet, much less the things that it will help us learn to survive on other planets, right? So the technology that we will develop for exploration what it will take to do water reclamation, what it will take to have energy sources on other planets. Those are the kinds of solutions that will solve significant problems on this planet for humankind. So I always like to make sure that we have the holistic conversation on this topic. That said, we are incredibly conscientious of these because we are commercial companies, right? So the last thing we want to do is be wasting any resources, putting anybody at risk that is not necessary. So we're very attentive to how we manage any of our fuel sources, how we locate our propellants. We do that on government facilities, right? Where we're doing that in partnership under significant environmental requirements. So one of the first things that we have to do before we can even progress with building a launch site, building a test stand, or even thinking about launching a launch vehicle is to go through a NEPA process. And depending on where you are, either the FAA, if you're at a private launch site, like for example, Blue Origin in Texas or SpaceX in Texas, then the FAA is the leading agency on that. And Sabrina can speak more to her experience with the FAA's process there. Or if you're on, for example, the federal range or a NASA facility, then those agencies are the leading agency in the NEPA review. And you may be in a categorical exclusion, you may have to do an EA, or you may have to do a full EIS, depending on your activity and the impact that is the concerning impact or potential impact there. And then, of course, you have to mitigate, right? So you have to take the actions in compliance with your environmental review to mitigate those actions. So I think that there's a lot of alignment. And in many of those cases, they're terrestrial activities that are, no different than other industrial terrestrial activities that are overseen in similar fashions. So, we're another industry that's complying with those NEPA requirements. And then I think when we get to space activities, then we're talking in some cases about sustainability, right? What are we doing with deorbiting our second stages, or making sure that we are being successful in locating those into parking orbits so that we're, being responsible, pursuing responsible behavior in space. So as a launch company, you're very much incentivized to make sure that you're being responsible there, because you want your customers to be able to get to space and conduct their activities in space. So the last thing I want to do is leave something in orbit that would minimize a capability for a customer that would be a paying customer in the future to use that orbit. So we're very, very thoughtful about that in the construction and the activities that we undertake with both our stages and our vehicles. And then, of course, to the extent that we're engaging in activities that go beyond, whether it's the moon, Mars, then we're engaged in conversations very much about, what are the requirements that we'll face depending on our licensing activity. And this will be part of the conversation with regard to the Department of Commerce and in-space novel activities, right? Because right now, the FAA is a means to getting a payload review to conduct activities. So we certainly are being attentive to our Article 6 requirements for authorizing and continuing supervision. And this is part of that process. But in the future, we are, we at Relativity, I also happen to be the chair of the board of the Commercial Spaceflight Federation right now. That industry association endorses the idea that the Department of Commerce is a good place to house the oversight of novel, non-traditional in space, depending on what you want to call it, activities and the licensing regime for that. And that will be part of the conversation of, depending on what you're doing, they'll be looking at your activity for compliance with requirements that will have to go through a regulatory process. So, through the Administrative Procedures Act and published so that we all have notice, because this is a key aspect of operating as a commercial entity, is the right to understand in the US what the regulations are and having, comment periods with regards to those. That is different than when we're acting as a service provider, for example, to a government customer, where it's going to be the government's requirements. And the government sometimes has different requirements. And the government, for example, has been able to waive, for example, orbital debris requirements. So we have, orbital debris requirements that the government will waive for its payloads. And if you're servicing that payload, then you're operating you're conducting yourself in accordance with your government customer and their requirements, which is different than the level of transparency that's required, as you all know, under the APA for regulations for licensing activities. So it's a little bit of a long answer to a question, but it's a very important question and very important to put it in context with all of these activities. And I think what are very thoughtful, responsible actors in space. In fact, many of us in space are pursuing our activities specifically with the goal of improving life on Earth, right? So, Relativity, the idea of what you can accomplish with 3D printing and the amount of benefit that we will see terrestrially, much less in exploration. And other companies, for example, Blue Origin, right, thinking about that activity, even SpaceX, providing activities on Earth, and the idea of protecting the species with the multi-planetary species goal. So I'll stop there.
I'll just pick up from a government contract perspective where you were going. So from a government contracts perspective, we do have to follow the regulations that are in the contract that we have with the government, even when we have subcontractors, even when they're commercial. So they have to follow those strict rules. So generally environmental regulations, any combustible materials, anything we have to work those very carefully, protect the safety of the people on the ground, ultimately whatever goes into space. So we do have those requirements and we follow them to the letter. And then subcontractors, even if they're commercial, have to follow those requirements. If there's an accident, of course, then it'll be case, who has most liability and who's going to clean up. But as a corporation, Lockheed Martin, we are engaged in environmental cleanups whenever we are have responsibility, either through our current sites or our legacy sites. So I think, at least on Earth, from a government contract perspective, there's a lot of protections.
Going to ask a question to Sabrina and then open if any of the commercial partners have further comment. So the FAA, as one of the entities that regulates our commercial space industry in the United States, has the dual mission both to regulate and to promote the development of our commercial space sector, which is inherently in a certain amount of tension, right? So there's that requirement to balance those two missions that the FAA has been handed. So I'm interested in your perspective on how the FAA balances that regulatory function with the promotion of the commercial space sector, the development of the commercial space sector. And then after that, if any of the commercial folks want to jump in on your perspectives on how you've seen the FAA executing that balance and if that's working well for the development of the US commercial space industry.
Sure. So as we regularly say, safety is our North Star. And so safety is always going to trump anything else that we do. Now, the promotion prong of our statutory authority is interesting. Actually, on the aviation side, they had a similar authority originally, and then there were some pretty bad accidents, and Congress decided to take it away, and Congress has thought about taking it away for us as well. The way that we kind of interpret our promotion responsibility is sort of what I described earlier, is working with industry in the ways that we are able to ensure that they are able to do what they need to do. Now, that means that they have to do it safely, but that also means that we are constantly engaging with industry, either through our rulemaking efforts, through CompStack, through various other industry outreach opportunities that the government has, to find out what is it that we need to do to make sure that you're able to conduct the types of operations that you need to conduct. Our statute originally came down in 1984. We actually based a lot of our safety regulations on Air Force requirements, and that was a big part of why 450 was so important, was to streamline and update the licensing requirements that had been kind of a little bit stale and a little bit prescriptive. May not have gotten it all right, but we are continuing to work with industry to try to make sure that we are keeping those regulations performance-based and up to date. And I think in those ways, engaging with industry, trying to stay on top of a constantly changing and innovating industry, that we ensure that our regulations are correct. Another thing that I think about in that vein is Part 460 in human spaceflight. So we are currently under a moratorium set by Congress not to regulate human spaceflight, but there is this question as to what can the FAA do, what can the government do to ensure that we are providing some insight and some guidance to industry to the extent that they're interested in conducting these types of operations, because it's happening now. And to Karen's point, there is something to be said for predictability. There's something to be said for knowing what is expected of you by the government, as opposed to just kind of jumping in and hitting roadblock after roadblock. And there is something to be said for having regulations that industry can hold us accountable to and say, hey, we've actually met all of your requirements, so you need to let us do this thing. So for human spaceflight, this is another example of where FAA is thinking about how can we help move this discussion and help enable these operations in a safe manner? How can we contribute to that going forward, especially while we're under a moratorium? So again, through ComStack, through engagement with industry, et cetera, we try to make sure that we are staying on top of things and that we know where the pressure points are. And I would say we do this sometimes better than other times, but we are constantly trying. And I think that public-private partnership is really important in our promotion authority as well.
It's really important to note, and it was brought up this morning about why would people want to partner with the United States and not China, or what is our edge? And we have the most robust regulatory regime of any country in the world, and it's a transparent one. I mean, the FAA and FCC and Commerce are always asking for comments, and so it's really important, I think, to continue to be the world leaders. It's hard on our private entities, but I think all of us are better for it.
And I think that part of what I see as the FAA's promotion authority is the work that they do internationally to engage with other countries that are interested in setting up regulatory regimes, or where US companies are looking, for example, to do point-to-point capabilities, right? So, one of the futures of space capabilities is potentially the ability to deliver cargo, to deliver people, whether that's, tourist activities or in service of government interests from one place on this planet to another. And so I see that as part of the promotional activity. I'll note and be aware that this could be a bit inflammatory, that despite not having the promotion authority anymore on the aviation side, there have still been accidents. And that, that I actually think that the promotion authority and the safety component at FAA AST are not in conflict with each other. And I agree with Sabrina that the safety side is very much the first and foremost activity on their minds with regard to their engagement with industry. There is nothing about promotion that comes into the conversation when I am pursuing a license to engage my activities. Despite my efforts sometimes to say, but aren't you interested in promoting me getting a license? It's have you satisfied all of the safety requirements, even if we're sometimes in disagreement about how one might go about doing so. So I do think that I think that it is a misnomer to say that personally, given my years of experience with dealing with the agency and seeing its representatives operate, to say that they're in conflict with each other or that the promotion activity is ever really an aspect of a licensing activity.
Even within the US government, I think that the FAA and all of the agencies, right, play a role in sort of promoting, but the FAA kind of really takes this as its own role in reducing duplication. As Karen mentioned, like there's still a number of places that you have to go and a number of agencies that you have to talk to in order to get your operation authorized. And it is a long and winding and thorny road. And one of the things that I think we as a US government, but especially with the FAA, have tried to make very much our mission is to say, where can we reduce duplication? Where can we reduce duplication amongst the government, especially as we're talking about these additional authorities and where they should go, et cetera. Regardless of where they end up, how can the government work together so that all of that complication maybe can be dealt with on the government side and doesn't have to be industry's burden? And I think that's another way that we can really promote industry, is to streamline that as much as possible.
Okay, do we have questions out in the audience? Yes.
Yeah, thank you very much. Another sustainability related question. And I appreciate the commitment you all expressed to protecting the environment on Earth. I know Professor Hanlon's done some good work on lunar heritage sites. Curious about regulating what mega constellations are doing to the night sky. I admit to being an amateur astronomer, and it's been amazing already what a difference the increase in the number of satellites has made. And I'm wondering, do you think we ought to have, could you say a little about the concern that companies have for trying to reduce the visual impact as we go to tens and hundreds of thousands of satellites? And do you think we need some regulation in that area? Thank you.
I'll jump in on this one. Again, I'm speaking on behalf of myself here, and I have limited experience with them. There are a number of constellations that are in works right now, and some really exciting work that's happening. And I happen to be a little bit more familiar with one than some of the others. And my experience there was a definitive dedication to trying to address this and to engaging meaningfully with the astronomy community to find solutions for that outcome. Again, I think there's a bigger conversation that can be had there about, the benefits and the costs and what are we balancing. And I think that's really important for us always to keep in mind with any activities, whether it's your personal life or your professional life and your professional outcomes is, everything is not necessarily black and white. And to the point about the sky. So I think that's my impression there is that there's been an extreme effort to try and address that while also having the outcome of pursuing the goal of the constellation. And to the point about transparency, and the FCC's docket is fully transparent. So, I think that there are benefits of that and there are costs of that. And that is one of the benefits, is that this is something that we've all seen play out and we will continue to see to play out. One point I will make about it, though, is the ability to forum shop here, and the importance of, whether these constellations are subject to U.S. law and to our transparent process and to that comment, versus able to be licensed in other countries, get to have landing rights in the United States and not be subject to that full transparent discussion. And that is something that is true and part of the conversation I think that's happening at the FCC. And while we're talking about the FCC, I'll also note that, the FCC is an independent entity. So it's always interesting to have conversations about this holistic, like what it is to be licensed in the United States and to engage as a commercial company in the United States, and have not have a whole of government approach for some things that should be whole of government, for example, orbital debris policies. So, astronomy, impacts. These are things where the FCC can, acts independently. And so it's, again, ties back even to the role of the FAA and the promotional authority and the efforts to engage, through the National Space Council and their leadership to say, okay, what should be a whole of government policy, because it's going to affect all of industry, despite the diversity of actors in industry. And then you have this one, could potentially have an outlier that if you're subject to the FCC, then you're doing one thing with that agency and something different for the rest of government. So I think it's so two important points there. One is the independence of the FCC, and two is the forum shopping that can occur to avoid those FCC regulations.
Because I was involved in SATCON 2 last summer, and we prepared a report on dark and quiet skies. And I want to just reiterate, the commercial space is involved in these, and it's not no, this is what we need and we're walking out. This is very much a concerted effort to achieve the right balance between getting the services down to earth that we need without blocking astronomy. This is the kind of issue that we're just going to be facing over and over and over again. For forum shopping, but also because there are some incredible benefits from space that we need to take advantage of to help our people on Earth. And so, the good news about dark and quiet skies is they do have a very strong berth at the United Nations Committee on the Peaceful Uses of Outer Space. Whatever we think about how that committee works, it is a great opportunity for nations to come together and decide, even maybe independently of the international community as a whole, but we can get national legislation that looks the same. But I think ultimately we do have to think about spending the money to move our astronomy to the far side of the moon. Our orbits are just going to get more and more crowded, and we have to balance that measure, but also think about the future.
You just reminded me of an opportunity to give a shout out to another agency that's involved in space, the State Department, who's been, and they've been making really good efforts to engage industry in conversations at the UN, which is an evolution in the ways that they've engaged with the commercial industry as the commercial industry has expanded and has become such a significant, has had such a significant impact on some of those conversations. So I do want to acknowledge their efforts there too.
So I'll also take a moment of prerogative to jump in on this discussion that I think is very interesting, especially in light of the forum shopping question and the point that Michelle raised about discussions in COPUOS. in the space law community, we've had lots of discussions about this exact issue. And one of the things that I find most interesting is the question about whether or not dark skies and astronomy performed from Earth into space really falls anywhere within the international regime that's relevant for that piece of it, right? To harmonize at the international level under international space law. Personally, I find it very challenging to see how we could fit astronomy from Earth to observe space within the Outer Space Treaty regime. And that's a much longer discussion, but in particular, certainly due regard is one question that gets asked. Okay, well, are we acting with due regard when we are destroying the ability for people to see into the night sky from Earth? But ultimately, that due regard provision in Article 9 is for corresponding activities, right? So you carry out your space activities with due regard for other states' corresponding activities. And so when we're talking about these space activities, reading through the Outer Space Treaty, we talk about space objects, we talk about launches and launching states. Really, what we're contemplating in the Outer Space Treaty, to me, does not look like that kind of an activity that you're observing space from Earth. That's not to say it's not a worthwhile pursuit to preserve the ability to observe space from Earth, but perhaps that is best handled at this stage at that domestic level, and also, you know, in conversation between the countries that are undertaking these activities, that are the forums really that are where these companies are going to perform these activities to try to balance that, because it's not something that fits neatly easily within the Outer Space Treaty regime, but is something that gets discussed at COPUOS because it is an interest that many states have, and it's certainly something that folks are aware of. There's a question in the front here.
Thank you. Laura Cummings, Astroscale US. I wanted to ask a question around integrated infrastructure and the comment earlier about having instances where one part of the government maybe has a preference for something that the other part of the government isn't necessarily allowing. So looking at the history of launch, and my understanding is that currently even most launches are conducted from federal launch ranges, meaning that they use spectrum that is for federal operators. Versus having a commercial operator who wants to not go talk to NTIA, but just the FCC, not have to coordinate their spectrum and have that ease of use. So is this an instance where there is an ability for federal launch ranges to incorporate commercial spectrum use, or is there some kind of statutory fix needed, like in the instance of government astronauts? Thank you.
So I'll jump in and say that one of the most important things, right, to understand a solution is to understand the problem and the root cause of the problem. And the root cause here is the infrastructure that's at the range that we need to communicate with in order to comply with range requirements. So we have to build our communication systems on our vehicle to meet those federal requirements. And that means that we're using their bands, right? And some of this will be alleviated as we move to autonomous flight safety systems. So, there's a requirement that all launch vehicles that are operating from the federal from ranges move to AFSS. So that is that essentially, if you're not familiar, takes the human out of the loop of hitting the button. It's software driven, and that requires less, more modern infrastructure and less of the spectrum use. And so we'll have less conflicts as a result of that. And we have to do that by October 2025, I believe is the right date. It's something that vehicles are definitely moving to, and that will relieve some of the burden on the communications there. But it is driven by those range requirements. So to the extent that and now, why do we fly from federal ranges? Well, we fly from federal ranges for a number of reasons. One is because we want to service federal customers. So the National Security Space Launch Phase 3 draft RFP was recently released. The industry days have been happening the last couple of days. And one of the requirements that has occurred in that has been that you need to launch East Coast, West Coast launch capabilities, and from a federal range, of course, because we're talking about national security payloads. NASA commercial crew and cargo launches from federal ranges. And then there's the challenge of finding property that is not on a federal range that can support launch. So do you have clear zones from population? Do you have flyover the capabilities? And, surprise, surprise, coastal property is very much in demand despite the increasing number of hurricanes that are hitting our country along our coasts, and or it's protected lands. So I had the pleasure of years ago, spending significant time trying to identify a location in the United States from which you could conduct an orbital launch and not be on federal property. And I'll tell you, there were like 2 places, and one of them is now taken. So it's a significant challenge. So there are a number of factors that drive to being on federal ranges, and then there's the use of the federal range and the requirements that you have to comply with that point you in that direction with regard to your communications capabilities.
So I'll jump in since you mentioned the questions about humans in the loop and bring in the discussion about AI, because I think that's something that across sectors, not just in space, but certainly in academia with the advent of ChatGPT, everybody is talking about AI. How do we regulate AI in the future? And so certainly from a safety perspective, regulation of AI in space for automated orbital adjustments, collision avoidance, that kind of stuff. Where are both the regulators and the commercial companies in thinking about and looking at the future of AI being integrated into these technologies? Do you have concerns? Do you have particular opportunities that you're looking at from that perspective?
I mean, I certainly think that cybersecurity is an important topic that the FAA is constantly looking at. For our purposes, we do have software regulations and requirements that I think should mostly address sort of the AI issues, just because it has to do with the security of your software systems and how they function essentially. So at the end of the day, if you're complying with our software requirements, there should be enough fidelity that you're not going to have any issues, particularly if your software systems are connected to like your FTS or an AFSS or something along those lines. It's very funny that you bring up ChatGPT because I'm on a conference about that later this week. So, but yeah, I mean, I think that we are just constantly looking at sort of developing cybersecurity concerns. And for us, we look at our software requirements and try to make sure that they're up to date and that they are comprehensive enough to address those issues.
Made me think that it would be kind of fun to try and draft a letter to Sabrina's team using ChatGPT for how I would be advocating for a rule change and seeing if I could pull from enough information from, like, say, example, the 450 rulemaking efforts and all the comments that are publicly available online to see if I could get it to generate a letter reiterating that many of the comments that the public made back then are still applicable to the rules that were adopted in 2020.
You could.
But otherwise, I concur with Sabrina's point on this, that the way that the rules read with the IV&V requirements for software systems certainly go after that problem, right? So independent verification and validation, the way that they look at your safety focused systems. And then of course there's a level like, so that's FAA again, segment this, that's FAA for FAA licensed launches. And then if you are licensed launching on behalf of the government, so whether it's a NASA certified launch or a now Space Force certified launch, the mission assurance requirements, that's where you'll get into those questions with regard to your ability to safely deliver those government payloads and the requirements they set in your contract for understanding certification of your vehicle, certification of your software that you're flying. And there are requirements for any material changes that the FAA would know that if you've made a change after you're licensed, or for your government customer, if you're launching multiple missions, the requirement that you stay up to date with your certification. And it's a big undertaking and one that the government involves other contractors in and expertise in. And so I see that as being a risk that is already addressed, and it'll just be a risk that is looking at this challenge the same way it looks at other challenges with regard to mission success and safety.
So yeah, I would add just AI beyond space. So AI in generally, obviously it's an important topic. It's the next generation. And as the companies are looking at AI and digital transformation, how does that all fit in? And then for the DoD perspective, they have their principles that we have to follow. And we have a whole policy on ethical use of AI. Obviously, in terms of deterrence and those kind of activities, there are still humans in the loop and will continue to be that. And there'll be long discussions about the proper use of AI, which is, I think, just beginning. And the power of AI, I think what none of us fully, I certainly don't understand. And but I think we have to watch that very carefully.
I would just add, because I like to think way out into the future, as we go from AI to machine learning and we send deep space missions where we don't have immediate contact to assist the AI or understand what the AI is seeing, what that AI will learn itself and what will happen then.
Good afternoon. This question is for the commercial representatives on the panel. With the increasing reliance of militaries on commercial space systems for military purposes, there have been proposals by NGOs that states require their space systems to be identified, marked through publication of registry or other means that differentiate between military systems, commercial systems used for military purposes, and purely civilian systems to aid in distinction and targeting during armed conflict. If such a policy was to be adopted by the US or by other nations, what impact do you think that would have on the commercial industry supporting military uses of space?
So I think that the next question that I have is, will that be implemented through our contracts, right? So what will that look like as a flow down from our government customer in terms of our requirements, or through the, will be adopted through the APA as a rule with our licensing. So, you're gonna have some kind of transparent process if it goes into a regulation, or you're gonna have some kind of negotiation situation if it's gonna be a requirement in your contract. So, a choice about doing business that way. And I think that I think it's an appropriate question to be having, right? In light of the other panels that we've heard and the discussions that we're having, what will that look like? And I think that it will look like something that will result, hopefully, from industry engagement ahead of a final result. And something that fulfills, an objective and a requirement that is, something in further support of our foreign policy interests and our national security, and in many ways, right, the safety of the systems that are being operated for commercial purposes. It will be really interesting if that comes to fruit, bears fruit, I should say, to engage with international commercial customers as well on that topic, right? Because on the commercial side, we obviously have U.S. government customers, we have domestic commercial customers, and then there are international commercial customers, which could be government and private sector customers. So it will be really interesting and important to have a very holistic conversation about that. You keep hearing me saying whole of government, holistic conversation about what that looks like. And I think, again, it just comes back to the importance and of transparency, which thankfully is a fundamental aspect of our democracy here.
I'll just make a point. It's not totally related to your question, but it is something that prompted me in terms of the relationship between commercial and military. And so we're fortunate enough to have both military and commercial, as I said in my remarks, very small commercial. And what I would say a lot of times in our terms of our commercial satellites, business case doesn't necessarily close for a large company like ours. But what we found is what we've learned from there and what we, any issues, we're able then to do lessons learned or make enhancements to our military satellites. So don't necessarily want all of commercial to go away, because we've actually used that as a learning platform.
A very unrealistic goal. I just don't think any government would want to tie itself to saying, I'm not going to use that technology, or we're going to let that company do whatever it wants, and we promise not to use their technology. I can't imagine tying our hands in that way.
One other thing that I'll note to Michelle's point there is also that, and this is a conversation I found myself having with regard to folks in government who are interested in procuring commercial services, is to what percentage will you be of my customer base, right? So how much am I willing to bear the pain of doing business with you if I am a majority commercial company? And the point about like cost and pricing data, right? So many commercial companies, including the ones that I've worked for, are focused on doing business with the government only under firm fixed price contracts, right? And that is a less painful way of doing business with the government, but there still can be very painful certification and requirements placed on those contracts. So if I'm going to only get one launch or one, small contract, and that's going to affect how I conduct myself as a business as a whole, then I may be willing to pass on giving you the benefit of my capability so as to protect myself as a commercial entity. And that may be even more so if I'm a publicly traded entity.
Say less painful, but a little bit more risky to do the firm fixed price contract, depending on whether there's development involved or anything like that. So you have to make that decision very carefully.
That has led me to another question, ladies, which is when we are looking at the options that commercial companies have to contract with the government from an acquisitions perspective, are the options that exist sufficient to really encourage innovation in the commercial sector, whether from the large legacy space companies like Lockheed Martin or some of the smaller, newer entrants, or are there new contracting vehicles, ways of conducting acquisitions that are going to be required from a commercial perspective in order to really take advantage of the innovation capabilities in the US commercial space sector?
I mean, I would say that NASA, the space, their version of other transactions are helpful too. And what we see sometimes is the commercial subcontractors are willing to work with us. We bear the pain, not that it's hard working for the US government in any way, shape or form. So but we bear that relationship with the government because we're kind of experts in it. We know how to work it. And then the commercial contracts can be somewhat, we act as the intermediary and they can do the work under that.
I'll commend NASA on this point, and that, having experience working on the cargo and crew programs and the way that those were staged first with Space Act agreements under their OTA, and then phased into FAR-based contracts for services. And one of the costs of the Space Act agreement approach is that you have to have significant skin in the game, and they have a requirement that it be something that can be commercialized. So it's not a one size fits all. But one of the things that was done really intelligently in that program was a scoping of the Space Act agreements, the SAAs, leading up to the FAR-based contracts. And then there were FAR-based contracts for the certification process, different from the FAR that were layered with the FAR-based contracts for the services. So what that allowed was an understanding of the progress and the innovation, and small bites at the final desired outcome and capability, small bites at that allowed scoping it appropriately, making sure the funding was there, and making sure that the partner was able to achieve the milestones in those agreements to then move into the final services agreement. And that was a very successful approach. In fact, you saw that it started on the cargo program, for example, with 2 providers. One of them wasn't able to meet their milestones, so another provider was brought in, and eventually those 2 providers that ended up servicing the cargo program. And you saw the same thing with crew, where you had multiple providers that were provided the first bite. So I think there were 3 in the first Space Act agreement, and then it narrowed down to 2, and we ended up with 2 service providers. And again, with that layering of that certification contract over that. It has been interesting to have conversations on the national security side about the tools in the contracting and procurement tool chest. And I often come back to, if you don't feel your tool is right, is it that you need a hammer versus a screwdriver, or do you just need a different size hammer or a different size screwdriver, right? It's not that you need to throw those out. And so it goes again to this idea of the scoping. Can you take bite-sized approaches so that you're feeding the innovation and feeding that R&D, but you're doing enough so that there's a vision towards the follow-on capabilities that you want to achieve. And so I think it's really about how do you make sure that those scopes, and I should say that the key aspect of that scope is are you clear on the requirements? So is this bite important to get to understanding the requirements of the final contract and what those will be? Because the worst thing in doing business with the government is to have undefined requirements, vague, ambiguous, whatever they may be, but to have the requirements not be clear, or not have the ability to really negotiate those requirements to fit the purpose of to fulfill the purpose, but to have some flexibility in how you get there.
So I see we have about 7 minutes left, so I think we have time for one more question. Is there a question from the online audience or from you?
We do have some questions, ma'am. And so for our online audience, again, if we did not get to your question, we sincerely apologize. But thank you for submitting those, and we'll see what we can do about answering them at a later date. A question, ma'am, I think is mostly for you, Sabrina. Karen mentioned a moment ago, kind of a whole of government effort. And one of the things that we're seeing a lot of is this emphasis on responsible behavior, right? We're seeing that from American representatives of the United Nations. We're seeing that from the US military. Could you, as a member of the FAA, speak to what responsible behavior looks like for you? And then I guess to open it up to the rest of the panelists too, any comments, concerns that you have about the efforts related to responsible behavior in outer space?
That's interesting because we are so laser focused on sort of our public safety mission. And I mean, to the extent that we have sort of the foreign policy and national security consultation with, the relevant agencies, I would say the FAA's regulations are so very focused on public safety, but one way that we're sort of veering into what I would describe more as responsible behavior in space is our orbital debris requirements, which is currently in the unified agenda, and the FAA is developing sort of a proposal on this. And it's interesting actually to look at orbital debris because the government has kind of been the leader on this. NASA has had, and then sort of the government-wide spacefaring government has had guidelines on this that they have followed, and the FAA has not incorporated those into sort of the commercial requirements. And so from a commercial perspective, they're not required to follow those guidelines. And so it felt a little bit like a square peg in a round hole, especially because I think, as Karen alluded to earlier, the FAA's authority is very limited to launch and reentry. And so when you start getting into some of the activities that we've touched on here, the novel space activities that might raise some of these responsible behavior questions, like the mega constellations, like some of the activities that will occur or are being proposed to occur on orbit, the FAA has kind of looked at its authority and said, we don't really have oversight here. The only times that we delve into that is during our payload review, which is fairly limited, again, to kind of public safety as it's related to launch and reentry and sort of our collision avoidance requirements. And so orbital debris has been an interesting one because we very firmly believe that ensuring that we are taking care to look at what is going to happen when we launch some of these things into space is an important aspect of making sure that we can continue to operate in space and continue to do some of these things. But the FAA kind of looked at it and said, do we really have the ability to issue these regulations? And actually the FCC took an interesting step in this approach as well, which is another example of Karen's point about sort of how the FCC is an independent agency. And the FCC has also been very bold in terms of how it's interpreted its authority, which is, kudos to them. But yeah, I think that the FAA is starting to get there, right? We're starting to look at, and this is largely also Congress needs to kind of say to the government, like, who in the government has the authority to do this? Is there a governmental approach that needs to be taken here? Should there be regulations around sort of space behavior and what's going on out there? And who should be vested with that? And should that be sprinkled throughout the government? Right now, I would say if you look at our legislation, our authority, there isn't a lot that speaks to that. But we are just like starting to take little steps in that direction.
I'd just add that, responsibility also means being responsible here on Earth when we have launches. And the FAA has done a very good job of making those environmental issues and addressing them and slowing down launch pace in order to make sure those are addressed. And I know that it's painful sometimes for commercial industry to have to deal with these kinds of regulations. But again, I think it shows us an important, very important part of the US global stature is that we are the responsible ones in the space game.
The only thing I will add to this is under the new Part 450 rules, the FAA asks questions about the payload that it didn't previously ask. And one of the things, this is an example of where industry was ahead of government in terms of responsibility, was before that requirement existed, members of industry did take the extra effort to make sure that we were coordinating with the State Department, that our customers were prepared to register their payloads, that they were appropriately licensed. Because, to the point about orbital debris, a lot of that oversight is is the authority of the entity that is licensing the activity in space versus the launch activity, right? We're delivering it, and then what it does beyond that may not be subject to US control, right? It may not be a US registered or licensed payload. So members of industry were taking a responsible approach there by saying, okay, we're going to make sure that our customers understand that they have to be licensed, where they are licensed, and that they're registered, and that we're coordinating with the State Department with regard to the registration convention requirements, and that we are sharing that information within our government. And I'll say that some of that came about with the eye-opening instance of what happened with an Indian launch of unlicensed payloads. And we all said, well, we would never want that to happen to us. And so we started proactively taking those actions. And the FAA has now, with the payload review, included a requirement that you give some information on that, including things like hazardous materials that are on board.
Well, that leaves us at about time. I want to give thanks to all of our panelists today. Thank you for contributing to this interesting discussion that I think has been a little bit distinct from some of the other topics discussed as part of the conference here. So I'm glad that our panel is bringing that topical diversity to the forefront here for the USSPACECOM Legal Conference. Thank you again to our hosts, USSPACECOM and USAFA, for the invitation to be here today.
A quick addendum to the conversation, if I might. We did endeavor to have human machine teaming for this conference in the form of having ChatGPT write some of our jokes. And let's just say that I think my job is safe for the time being. So thank you very much to Dr. Harrington and the entire panel. If you would please accept this token of our appreciation. Thank you very much.